Imagine being sentenced to 5 years in federal prison for possessing a tiny amount of one form of cocaine, while someone possessing 100 times more of another form could receive the same mandatory sentence. Same basic drug, different form, and under American law, a dramatically different punishment. This is the story of crack cocaine and powder cocaine, and one of the most controversial sentencing disparities in modern American history. Before we begin, if you enjoy calm, deeply researched history stories that explore the hidden side of America and the world, subscribe to Boring History for sleep. New historical journeys are always waiting here. Now, let us go back to the beginning. The story really starts before the laws were written, before the political speeches, and before the headlines that would eventually dominate American television. Cocaine itself was not a new discovery in the 20th century. For centuries, coca leaves had been used in South America, particularly in the Andes. The leaves came from the coca plant, and indigenous communities had used them for traditional purposes long before modern scientists isolated cocaine as a chemical substance. During the 19th century, European and American scientists became increasingly interested in coca leaves. Eventually, a concentrated substance called cocaine was isolated. What followed was a remarkable transformation. Cocaine moved from a traditional plant-based substance into laboratories, pharmacies, medical offices, and commercial products. In the late 19th and early 20th centuries, cocaine could be found in products that would seem astonishing by modern standards. It was used in some medical treatments. It appeared in certain patent medicines, and for a time its dangers were not fully understood. But as scientific knowledge changed, governments began placing greater restrictions on cocaine. By the 20th century, cocaine had become an illegal drug in the United States, and its use moved increasingly into underground markets. For decades, however, cocaine remained strongly associated with particular social groups. By the late 20th century, powder cocaine had developed an image connected with wealth, nightlife entertainment, and expensive lifestyles. It was a drug that could be extremely expensive. Then something changed. During the late 1970s and especially the early 1980s, a different form of cocaine began appearing much more visibly in American cities. This form became known as crack. Crack was not a completely different drug. It was another form of cocaine. But its method of preparation, appearance, price, and method of sale made it very different from the powder that had dominated the image of cocaine for years. Crack could be sold in very small quantities. That meant people who could not afford expensive amounts of powder cocaine could potentially purchase smaller amounts. The drug began spreading through some American urban neighborhoods, and the consequences were serious. Addiction affected families. Street-level drug markets expanded. Violence occurred in some communities. People became afraid of what was happening around them. And then came the media. Television news programs began showing dramatic images of American cities struggling with drugs and crime. Newspaper headlines warned of a new epidemic. Politicians began describing drugs as one of the greatest threats facing American communities. The word crack itself soon became one of the most recognizable words in America's growing war on drugs. But there was something important hidden beneath the panic. The public discussion often treated crack and powder cocaine as if they were two completely different substances. They were not. Both came from cocaine, yet the American legal system was about to create an enormous difference between them. To understand why that happened, we need to understand the America of the 1980s. The country was experiencing major social and economic changes. Some cities were struggling with unemployment, poverty, declining industries, and deteriorating neighborhoods. At the same time, violent crime was a major political concern. Americans were increasingly worried about safety. Parents worried about their children. Communities worried about drug dealers. Police departments were under pressure to respond. And politicians understood something very clearly. The public wanted action. The war on drugs had already become an important part of American politics. But the arrival of crack created an entirely new level of fear. Reports about crack were often dramatic. The drug was portrayed as cheap, highly addictive, and extremely dangerous. Stories about babies, families, violence, and ruined neighborhoods became part of the national conversation. Some of those problems were very real. Communities were genuinely suffering, but the political response would soon go far beyond ordinary policing. In Washington, lawmakers began discussing a major new federal drug law. The goal was simple on the surface: make drug trafficking more dangerous, increase prison sentences, give prosecutors stronger tools, and send a message that America would no longer tolerate the growing drug crisis. But the details of the new law would create a controversy that lasted for decades. In 1986, Congress passed the Anti-Drug Abuse Act. Among its many provisions were mandatory minimum sentences for certain federal drug offenses. Mandatory minimums were important because they limited the ability of judges to reduce sentences below a certain level when specific legal requirements were met. Instead of simply considering the individual circumstances of every defendant, the quantity and type of drug could trigger a predetermined minimum punishment. And this is where the story becomes extraordinary. The law established a dramatic difference between crack cocaine and powder cocaine. 5 grams of crack could trigger a 5-year mandatory minimum sentence. But to trigger the same 5-year mandatory minimum for powder cocaine, the threshold was 500 grams. 5 grams, compared with 500 grams. That was a ratio of 100 to 1. Imagine placing the two amounts on a table. On one side, a tiny quantity. On the other, 100 times as much. Yet under the federal sentencing rules, they could lead to the same mandatory minimum sentence. The difference became known as the 100 to 1 sentencing disparity. At the time, supporters of the policy argued that crack was more dangerous. They pointed to its rapid spread, its connection with street-level drug markets, and concerns about addiction and violence. The argument was that crack created unique social harms and therefore deserved harsher punishment. But critics began asking a simple question. Was the difference really justified? Was crack truly so different from powder cocaine that one form deserved dramatically greater punishment? And perhaps most importantly, what would happen to the people who were caught under this new system? Those questions would become increasingly important as thousands of federal drug cases moved through American courts. For defendants, the new rules were not theoretical. They could determine years of someone's life. A person could stand before a federal judge and hear a sentence measured not in months, but in years or even decades. Families could lose fathers. Children could grow up without parents. Communities could lose large numbers of people to the prison system. And the consequences were not evenly distributed. Critics soon noticed that the harsh crack penalties were disproportionately affecting Black Americans. This did not mean that every person sentenced under the law was black. Nor did it mean that every drug-related problem was unique to one community, but the racial impact of the sentencing system became impossible to ignore. Civil rights organizations, defense attorneys, researchers, and community activists began examining the statistics. They questioned whether a law created during a period of intense public fear had produced a fair system of justice. Meanwhile, supporters continued to argue that the government had a responsibility to protect communities from dangerous drugs. The debate became increasingly complicated. On one side was the fear of addiction, violence, and devastated neighborhoods. On the other was the question of proportional punishment and equal justice. And somewhere between those arguments were thousands of ordinary people whose lives were changed by the law. For years, the 100 to 1 disparity remained part of federal drug sentencing. But criticism did not disappear. Instead, it grew. Researchers began studying the science behind the original assumptions about crack. Lawyers challenged sentences. Civil rights groups demanded reform. Community leaders spoke about families separated by long prison terms. And gradually, the political conversation began to change. The country that had once demanded the harshest possible response to drugs was beginning to ask whether the response itself had gone too far. But changing federal law would not be easy. The crack epidemic had become deeply connected with the history of the war on drugs. The sentencing rules had already affected thousands of people, and correcting the disparity raised another difficult question. What should happen to people who had already been sentenced under the old system? Should new rules apply only to future cases? Should people already in prison receive consideration? Could a law created during a national crisis be rewritten decades later? These questions would continue through the 1990s and into the 21st century. And eventually, after years of political debate and public pressure, Congress would take another major step. In 2010, lawmakers passed the Fair Sentencing Act. The law did not completely erase the difference between crack and powder cocaine, but it dramatically reduced the old disparity. The 100-to-1 ratio was changed to 18-to-1. It was a major shift. For the first time in decades, the federal government had officially moved away from the extreme sentencing difference created during the height of the 1980s drug war. But even then, the story was not over. Because changing a law does not automatically undo the past, people who had already received long sentences still had to live with the consequences. Families still carried memories of years lost. Communities still remembered the impact. And historians, lawyers, and researchers continued asking the same fundamental question. How did America reach the point where 5 grams of one form of cocaine could be treated like 500 grams of another? The answer is not found in one law, one politician, or one event. It is found in a much larger story. A story about fear. A story about politics. A story about crime. A story about addiction. A story about race. And above all, a story about how a nation responds when it believes it is facing an emergency. The history of crack and powder cocaine is therefore not simply a story about drugs. It is a story about American society itself. And as we continue deeper into this history, we will look at what actually happened during the crack epidemic, why lawmakers believed such severe punishment was necessary, how the 100-to-1 rule was created, and why its consequences became one of the most controversial chapters in America's modern justice system. The story of the crack epidemic cannot be understood without first understanding the neighborhoods where it appeared. During the 1980s, many American cities were already experiencing serious economic problems. Factories had closed or moved away. Unemployment was high in some communities. Buildings were deteriorating. Families were struggling, and opportunities were often limited. Into these conditions came a rapidly expanding illegal drug market. Crack was particularly suited to street-level sales because it could be divided into very small quantities. A person did not need to have a large amount of money to buy it. This made the drug accessible to people who could not afford larger quantities of powder cocaine. As demand grew, so did the businesses surrounding the drug trade. Dealers competed for customers. Street corners became important locations, and in some neighborhoods, disputes between competing groups contributed to violence. But it is important to remember that the crack epidemic was not simply a story of violence. For many families, the greatest danger was addiction. People who became dependent could spend increasing amounts of money trying to obtain the drug. Relationships suffered. Jobs were lost. Children were affected. Parents watched relatives change before their eyes. Treatment programs existed, but they were often limited compared with the scale of the problem. And while families were dealing with the consequences, television cameras were beginning to tell the story to the rest of America. The images were powerful: police officers searching buildings, people being arrested, abandoned buildings, families describing the destruction caused by addiction, and reporters standing on city streets explaining that a new and frightening drug had arrived. The coverage helped create a national sense of urgency. Americans who had never seen crack themselves were suddenly seeing it every night on television. Politicians quickly understood the power of this issue. Talking about drugs was no longer simply talking about public health. It was talking about crime. It was talking about children. It was talking about neighborhoods. And it was talking about the safety of the country. The phrase war on drugs became increasingly common. The idea behind it was straightforward. If illegal drugs were treated as an enemy, then law enforcement would fight that enemy with greater resources and stronger punishment. More police, more arrests, longer prison sentences, and tougher federal laws. The approach was popular with many voters. People who were frightened by the growing drug problem wanted to see government action. They wanted their streets to become safer. They wanted dealers removed from their neighborhoods. And they wanted politicians to demonstrate that they were serious. This political environment helped produce the Anti-Drug Abuse Act of 1986. But there was another important factor. Lawmakers were not only reacting to statistics, they were reacting to stories. One particular tragedy became extremely influential in the national debate. In 1986, a young basketball player named Len Bias died of a cocaine overdose shortly after being drafted by the Boston Celtics. His death received enormous attention. Bias was young, successful, athletic, and seemingly had his entire future ahead of him. His sudden death shocked the country. Although the details surrounding cocaine, powder cocaine, and crack were often discussed in confusing ways during this period, the tragedy became part of the growing political demand for stronger drug laws. Another highly publicized death followed soon afterward. University of Maryland basketball player Hank Gathers was also associated with the growing national conversation about drug use and young people, although his death was actually caused by a heart condition rather than cocaine. The broader atmosphere was already filled with fear. America was becoming convinced that drugs were destroying a generation. And when politicians are under pressure during a crisis, laws can move very quickly. The Anti-Drug Abuse Act passed in 1986. One of its most important features was the creation of mandatory minimum sentences based on drug type and quantity. The crack-to-powder ratio was extraordinary. 5 grams of crack could result in a 5-year mandatory minimum. 50 grams could result in a 10-year mandatory minimum. For powder cocaine, the quantities required to trigger those same penalties were dramatically higher. 500 grams for 5 years, 5 kilograms for 10 years. That meant the law treated 1 gram of crack as legally equivalent to 100 grams of powder cocaine for sentencing purposes. But where did this ratio come from? That question would become central to the later controversy. At the time, lawmakers argued that crack was different from powder cocaine. They believed crack was more addictive. They believed it produced more intense effects. They worried that crack users were more likely to become dependent. They also believed crack was strongly connected to violence and street crime. Some lawmakers argued that crack posed a special threat to pregnant women and unborn children. These concerns helped create the justification for harsher penalties. But years later, researchers began questioning many of the assumptions behind the original law. They found that the scientific evidence did not clearly support such an enormous difference in punishment. Crack and powder cocaine have the same active chemical ingredient. The main difference is the physical form in which the drug is consumed. That does not mean the two forms are identical in every practical way. But the question was whether the differences were large enough to justify a 100-to-1 sentencing ratio. Critics increasingly argued that they were not. And then there was the racial dimension. The majority of people sentenced for federal crack offenses were black. This was partly connected to patterns of drug enforcement and where crack markets were concentrated. But it meant that a law written in the name of fighting drugs was having a particularly heavy effect on black communities. Civil rights organizations began describing the sentencing system as discriminatory. Defense attorneys argued that people were receiving disproportionately long sentences. Researchers began examining federal sentencing statistics, and families began telling their own stories. A mother might watch her son receive a sentence lasting many years. Children might grow up while a parent was in prison. A family could lose an important source of income. A neighborhood could lose hundreds of residents over time. The prison system became one of the most visible consequences of the war on drugs. The federal government was not simply arresting people. It was sending them away for long periods, and once someone entered the federal prison system, the consequences could extend far beyond the sentence itself. Finding employment afterward could become difficult. Rebuilding family relationships could take years. Housing could become harder to obtain, and the label of a criminal conviction could follow someone for the rest of their life. Supporters of harsh sentencing, however, continued to defend the policies. They argued that communities had suffered terribly from crack. They pointed to addiction. They pointed to violence. They pointed to children growing up around drug markets. And they argued that strong punishment could deter people from entering the drug trade. This created a difficult debate. Was harsh punishment protecting communities, or was it creating another form of destruction? Could imprisonment reduce the supply of drugs, or would another person simply take the place of the person who had been arrested? Could addiction be solved through prison, or did people need treatment instead? These questions had no simple answers, and America continued to debate them for years. By the 1990s, the original panic surrounding crack had begun to change. The epidemic was still affecting communities, but the public conversation was becoming more complicated. Researchers were looking at the actual medical effects of crack and powder cocaine. Legal scholars were examining sentencing practices. Civil rights groups were documenting racial disparities, and lawmakers were beginning to hear increasingly strong demands for reform, yet changing the law remained politically difficult. No politician wanted to appear soft on drugs. The memory of the 1980s was still powerful. The public had watched neighborhoods suffer. People remembered the images, they remembered the fear, they remembered the stories of addiction and violence, and many believed that reducing penalties could send the wrong message. So the 100-to-1 ratio remained, year after year, case after case, person after person. The federal courts continued applying the same basic distinction: 5 grams versus 500 grams, a tiny quantity versus a much larger quantity, same mandatory minimum, different form of cocaine. The disparity eventually became a symbol of a larger problem in American criminal justice. It represented the question of whether punishment should be based primarily on the substance involved, the amount involved, the person's role in the offense, or the broader circumstances surrounding the crime. It also raised another important question. What happens when a law created during a national emergency turns out to have consequences far greater than originally expected? Once thousands of people have been sentenced, changing the rules becomes extremely complicated. A new law can change future cases, but what about people already serving sentences? That question would become one of the central issues in the long campaign for sentencing reform. During the 1990s and early 2000s, pressure for change continued to build. Researchers published studies. Legal organizations released reports. Community activists organized meetings. Lawyers challenged the assumptions behind the old sentencing structure. And slowly, the political atmosphere began to shift. The country was no longer asking only how to punish drug dealers. It was beginning to ask whether the punishment itself was fair. That change in thinking would eventually lead Congress toward a historic decision. But before that happened, the old system had already left a deep mark on American society. Thousands of people had received long federal sentences. Families had spent years waiting for loved ones to come home. Communities had experienced enormous disruption, and the 100-to-1 ratio had become one of the most recognizable examples of unequal sentencing in modern American history. The debate was no longer simply about crack and powder cocaine. It had become a debate about justice itself, and that debate was about to enter a new chapter. The 1990s brought an important change to the conversation surrounding crack cocaine and federal sentencing. The fear that had dominated the 1980s was still present, but the first wave of research was beginning to challenge some of the assumptions behind the harshest laws. Scientists, medical professionals, lawyers, and researchers began looking more carefully at the differences between crack and powder cocaine. They found something that was difficult to ignore. Both substances contained the same active chemical compound. The major difference was the form in which the cocaine was prepared and consumed. That did not mean the two forms had identical effects in every situation. But critics increasingly questioned whether the difference was large enough to justify a 100-to-1 sentencing disparity. The question became even more important because the people receiving these sentences were real individuals. A federal courtroom could look calm from the outside. Inside, however, a sentencing hearing could completely change a family's future. A defendant might stand beside an attorney while a judge reviewed the charges. The family could sit quietly behind them. Everyone in the room might understand that a decision was about to be made that could affect someone's life for many years. Under mandatory minimum rules, judges had limited freedom. If a defendant was convicted of an offense involving a certain quantity of crack, the law could require a minimum sentence regardless of the judge's personal opinion about the circumstances. This was one of the major goals of mandatory sentencing. Congress wanted consistency. The idea was that people committing similar crimes should receive similar punishment. But the crack sentencing system produced another kind of inconsistency. The quantity required to trigger a sentence was dramatically different depending on whether the cocaine was in crack or powder form. and that difference could translate into years of someone's life. During the 1990s, legal organizations began documenting these effects. Researchers studied federal sentencing data. They compared defendants. They examined race. They looked at drug quantities. And again the same pattern appeared. Crack sentencing was having a disproportionate impact on black defendants. This became a major concern for civil rights organizations. The argument was not simply that drug laws were strict. It was that a particular sentencing structure was creating unequal consequences. Imagine two defendants appearing in federal court. One is convicted of a crack offense. Another is convicted of a powder cocaine offense. The circumstances could be similar, but the quantity required to trigger the same mandatory sentence could be radically different. That difference was difficult to explain to families. It was also becoming increasingly difficult to defend scientifically. Still, reform did not happen immediately. The war on drugs remained politically powerful. Many Americans continued to believe that harsh sentencing was necessary. Politicians were cautious, and the federal government continued enforcing the existing rules. Meanwhile, the social consequences accumulated. People who had received long sentences spent years inside federal prisons. Some were young when they entered. By the time they returned home, their children had grown up. Parents had become elderly. Relationships had changed. Neighborhoods had changed. The outside world itself had changed. Someone who entered prison in the late 1980s could eventually return to a country that looked completely different from the one they remembered. Technology had changed. Music had changed. Cars had changed. Communication had changed. Even ordinary daily life had changed. But the prison sentence remained. For families, these long sentences could be especially painful. A child might send letters to a parent in prison. A mother might travel long distances to visit a son. A wife might raise children without her husband. And sometimes families simply lost contact. These were consequences that could not be measured by a sentencing table. They were human consequences. By the late 1990s, the debate over crack sentencing was becoming part of a much larger discussion about mass incarceration in America. The United States had one of the world's largest prison populations. Federal and state prisons were filled with people convicted of drug offenses and other crimes. Researchers began asking whether extremely long sentences were actually producing safer communities. Some argued that incarceration was necessary. Others argued that the country had gone too far. The crack sentencing disparity became an important example in that debate. It showed how a law created in response to a specific crisis could continue affecting society decades later. But there was another reason the disparity attracted attention. The original 100-to-1 ratio had not been based on a precise scientific formula. The ratio had emerged during a period of intense political pressure. Lawmakers were responding to a frightening and rapidly developing drug crisis. The country wanted action, and in that atmosphere, the government chose extremely severe penalties. Years later, critics looked back and asked whether the policy had been built on assumptions that were never adequately tested. That question became increasingly uncomfortable. Was crack really 100 times more deserving of punishment than powder cocaine? Was the difference in harm really that enormous? And if not, why should the legal system continue treating them so differently? These questions began appearing in congressional hearings, academic papers, legal arguments, and public discussions. The debate was slowly moving away from the emotional atmosphere of the 1980s. Instead of asking only, how do we stop drugs, people were also asking, how should we punish people? Those are not the same question. Stopping drug trafficking and deciding how long someone should spend in prison are related, but they require different kinds of decisions. A society can believe drugs are dangerous and still debate whether every offense deserves an extremely long mandatory sentence. This distinction became increasingly important. Treatment advocates argued that addiction should be approached partly as a public health issue. Lawyers argued that judges needed more discretion. Researchers argued that sentencing should be based on reliable evidence. Community leaders argued that families and neighborhoods should not be destroyed by policies designed to protect them. And civil rights organizations continued pointing to racial disparities. The pressure slowly increased, but reform required more than public discussion. Congress had to act, and Congress had already shown during the 1980s that it could pass major drug legislation very quickly when public pressure was intense. The challenge in the new century was almost the opposite. Now lawmakers had to convince the public that changing the law did not mean surrendering the fight against drugs. They needed to argue that fairness and public safety could exist together. That distinction became central to the reform movement. One of the strongest arguments for change was simple. If the science did not support the enormous difference between crack and powder cocaine, then the law should be changed. The question was how much it should be changed. Some reform advocates wanted the disparity eliminated completely, others proposed reducing it, and some lawmakers remained concerned that reducing crack penalties could create new risks. The debate continued. Meanwhile, the people already serving sentences remained at the center of the issue. Suppose Congress changed the law tomorrow. Would someone sentenced under the old rules automatically receive a shorter sentence? Not necessarily. The legal system generally distinguishes between new laws and old convictions. Changing a sentencing rule does not automatically erase a sentence that was legally imposed under the rules that existed at the time. That meant reformers had to confront a difficult question. Should new sentencing rules apply retroactively? If so, how far back should they go? And who should decide which prisoners deserved relief? These questions would eventually lead to years of additional debate. During this period, the history of the crack sentencing disparity became increasingly well known. It was discussed in universities, it was studied by legal scholars, it was examined by journalists, and it became an example used in broader conversations about racial inequality and criminal justice. The story also became personal. People who had served long sentences began speaking publicly about their experiences. Some described entering prison as young adults and returning as middle-aged men. Some described missing the childhoods of their children. Others talked about the difficulty of rebuilding their lives after release. Their stories gave the debate a human face. A sentencing table might show numbers, but behind every number was a person. Behind every sentence was a family, and behind every prison population statistic were thousands of individual stories. This was one reason the debate refused to disappear. The original law had been created during a period of crisis, but by the 2000s, America had more time to evaluate its consequences. Researchers had more data, doctors had more evidence, legal experts had decades of court cases to examine, and politicians had the benefit of hindsight. The question was no longer simply what America believed in 1986. It was whether America still believed the same thing decades later. The answer was increasingly clear. The 100-to-1 disparity was losing political support. Even people who supported strong drug enforcement began to acknowledge that the sentencing difference might be excessive. The debate shifted from whether reform was necessary to how reform should work. And then, after years of advocacy, something significant happened. Congress began moving toward legislation that would finally change the federal sentencing structure. The political moment had arrived. The old ratio that had shaped thousands of sentences was about to be reduced. But before that happened, lawmakers still had to confront the difficult legacy of the past. People were waiting, families were watching, lawyers were preparing arguments, and communities that had lived through decades of the war on drugs were waiting to see whether Washington would finally change the rules. The next chapter would become one of the most important moments in the entire history of crack and powder cocaine sentencing. In 2010, Congress would pass a law that dramatically changed the disparity. But the new law would not erase the past, and that would create another debate. Who should benefit from reform? Who should remain under the old rules? And could the government truly correct a policy without also addressing the people who had already suffered its consequences? Those questions would define the next stage of the story. By the beginning of the 21st century, the debate over crack and powder cocaine sentencing had changed dramatically. The fear that had dominated the 1980s was still part of the story, but the country now had decades of experience with the policy. Lawmakers could look back at the consequences. Researchers could examine years of sentencing data. Doctors and scientists could study the differences between crack and powder cocaine, and families could describe what those sentences had done to their lives. The evidence was becoming harder to ignore. The 100-to-1 ratio had created an enormous difference in punishment between two forms of the same basic drug, and that difference had fallen particularly heavily on Black Americans. For reform advocates, this was no longer simply a technical question about sentencing. It was a question about fairness. Could a justice system claim to treat people equally while punishing one form of cocaine so much more severely than another? The debate became especially important inside Congress. Lawmakers introduced proposals to reduce the disparity. Some wanted to eliminate the difference completely. Others wanted a compromise. They argued that crack and powder cocaine might have different patterns of use and distribution, but that the old ratio was simply too extreme. The political challenge was enormous. Supporters of reform had to convince their colleagues that reducing the disparity would not mean giving up on the fight against illegal drugs. They had to make a distinction between two ideas. One idea was that drugs could be dangerous. The other was that every person involved with drugs deserved an extremely severe mandatory sentence. Those ideas were not necessarily the same. This distinction gradually became more accepted. America had learned that punishment alone could not solve every problem associated with addiction. A person struggling with substance dependence might need treatment. A neighborhood suffering from poverty might need jobs and investment. A family affected by addiction might need support. And a person leaving prison might need a realistic opportunity to rebuild a life. These issues were much more complicated than simply increasing prison sentences. Still, the old sentencing rules remained. Federal prosecutors continued to use the law, judges continued to impose mandatory minimums, and defendants continued to face the consequences. Then, in 2010, Congress finally took a major step. The Fair Sentencing Act became law. It was one of the most important changes to federal cocaine sentencing in a generation. The law reduced the disparity between crack and powder cocaine from 100-to-1 to 18-to-1. That was a dramatic change. Instead of 5 grams of crack being treated as equivalent to 500 grams of powder cocaine for the 5-year mandatory minimum, the required crack quantity was increased substantially. The law also increased the amount of crack required to trigger the 10-year mandatory minimum. In other words, Congress was acknowledging that the old system had been too severe. But notice something important. The disparity was not completely eliminated. It was reduced. That detail mattered enormously to reform advocates. Some believed the remaining difference was still unjustified. They wanted a completely equal system. Others considered 18-to-1 a significant improvement. Either way, the old 100-to-1 ratio was finally gone for future sentencing under the new rules. But then another question appeared. What about people who had already been sentenced? This was where the story became much more complicated. Imagine someone who had been sentenced to 10 years under the old rules. Congress changes the law. The new law would have produced a shorter sentence for the same conduct. Does the person automatically receive the benefit? Not necessarily. The old sentence was imposed legally under the law that existed at the time. Changing the law for future cases does not automatically change every old sentence. This became one of the most important issues in the years following the Fair Sentencing Act. Reform advocates argued that it was unfair to change the law but leave thousands of people serving sentences under the old system. They argued that if Congress had acknowledged the old disparity was too harsh, then people already serving those sentences should have a chance to benefit. Opponents worried about retroactive changes. They argued that courts needed clear rules. They also worried about reopening thousands of old cases. The legal system now faced a difficult balancing act. How could it correct an outdated sentencing policy while maintaining consistency and finality? The debate continued. Meanwhile, the people serving old sentences waited. Some had already spent decades in prison. Others were approaching release. Some families hoped that reform would finally bring a loved one home earlier. Others had already lost years that could never be returned. A child who had been 6 years old when a parent went to prison might now be an adult. A parent who had once been young might now be elderly. A spouse might have rebuilt an entirely different life. This is one of the most difficult parts of criminal justice history. A sentence is measured in years. But human life is measured in moments: birthdays, graduations, weddings, funerals. First steps, last conversations. A prison sentence can remove someone from all of them. That is why sentencing debates are never just about numbers. The numbers represent lives. The Fair Sentencing Act was therefore both a legal change and a symbolic moment. It showed that the federal government was willing to admit that the old approach had been excessive. But it also showed how difficult it is to reverse the consequences of a law once that law has been in place for decades. The story continued into the following years. Courts had to interpret the new rules. Federal agencies had to apply them. Lawyers had to determine who might qualify for relief. And Congress continued hearing arguments about whether additional changes were necessary. The pressure for further reform did not disappear. Instead, it grew. One of the biggest arguments involved retroactivity. If a sentencing disparity was considered unfair, why should only future defendants benefit? That question became increasingly difficult for lawmakers to avoid, and the issue was not limited to crack cocaine. The entire American criminal justice system was undergoing a larger debate. The country was reconsidering mandatory minimums. It was reconsidering the length of prison sentences. It was discussing racial disparities. It was discussing rehabilitation. And it was questioning whether decades of mass incarceration had actually produced the results policymakers had originally promised. The crack sentencing debate became part of this larger movement. The old policy had been created with a specific goal: deter drug trafficking, protect communities, reduce the spread of crack. But after decades, people were asking whether the costs had become too high. There was another important change as well. The public understanding of addiction had evolved. During the height of the war on drugs, addiction was often discussed primarily as a criminal problem. By the 2000s and 2010s, more Americans were willing to discuss addiction as a medical and social problem. That did not mean drugs became acceptable. It meant that the response could include more than punishment: treatment, prevention, education, community support, and rehabilitation. These ideas increasingly entered the political conversation. The history of crack sentencing therefore reflected a broader change in American thinking. In the 1980s, the dominant question had been, how can we punish this problem? Decades later, another question was being asked: how can we solve this problem? Those questions lead to very different policies. But even as America changed its approach, the legacy of the old system remained. People released from prison faced another challenge: returning home. For someone who had spent 10, 15, or 20 years behind bars, the modern world could feel unfamiliar. Technology had transformed everyday life. Mobile phones had replaced many traditional forms of communication. The internet had changed how people worked and interacted. The job market had changed, neighborhoods had changed, and families had changed. Someone could leave prison and discover that their children were now adults. A person might meet grandchildren they had never known. Parents might have died. Friends might have moved away. The sentence was technically over, but the consequences continued. This is why historians often distinguish between the formal punishment and the long-term consequences of punishment. The formal punishment ends when the sentence ends. The consequences may continue for decades. Employment can be difficult. Housing can be difficult. Family relationships can be complicated. And the stigma of a criminal conviction can remain. For communities that experienced large numbers of incarcerations, the consequences could also continue. Entire neighborhoods could lose large numbers of working-age adults. Families could become dependent on relatives. Children could grow up with parents absent. And when people eventually returned home, communities had to adjust again. These effects were difficult to capture in government statistics. A sentencing report might list the number of convictions. It might list average sentence lengths. It might list prison populations. But it could not easily measure the emotional cost. It could not measure the birthday missed, the family gathering missed, the relationship that disappeared, or the years that could never be recovered. That is why the history of the crack sentencing disparity remains so powerful. It connects national politics with individual lives. A decision made inside a congressional chamber could eventually affect a family thousands of miles away. A sentence written into federal law could determine whether someone spent 5 years, 10 years, or much longer behind bars. And a number chosen during a political crisis could remain part of the justice system for decades. The Fair Sentencing Act marked a major turning point, but it was not the final chapter. The country still had to decide how much of the reform should reach people sentenced under the old rules, and it had to decide whether 18-1 was enough. For many reform advocates, the answer was no. They believed the remaining disparity was still too large. If crack and powder cocaine came from the same basic drug, why should the federal government continue treating them differently at all? That question would continue to shape the debate, and eventually, another major law would address part of that problem. But before we reach that moment, it is important to understand how the original sentencing system affected the people who lived through it. Because behind every law is a human story, and behind the 100-to-1 ratio were thousands of people whose lives were permanently changed. The most important part of this story is often hidden behind the numbers. When people hear about a sentencing ratio, they may imagine statistics, legal documents, and congressional debates. But every number represented a person who had a family, a person who had friends, a person who had plans for the future, and sometimes a person who had made one terrible decision that would follow them for decades. During the years when the 100-to-1 disparity was in effect, federal courts processed thousands of crack cocaine cases. Some defendants were major traffickers. Others played much smaller roles. Some were involved in organized drug operations. Others were low-level participants. But mandatory sentencing rules could make the quantity of crack involved extremely important. The law did not always distinguish between the person who controlled a drug operation and the person who played a minor role in it as much as critics believed it should. This became one of the major complaints about mandatory minimum sentencing. Judges could look at a defendant and believe that the legally required sentence was excessive, but their ability to go below the mandatory minimum was limited. The system was designed to remove some of that discretion. Supporters believed this created consistency. Critics believed it sometimes created injustice. Imagine a judge sitting in a federal courtroom. The judge has heard the evidence. The judge has listened to the lawyers. The judge has seen the defendant. The judge may know about the defendant's family, education, employment history, addiction, or lack of previous convictions, but then the law says there is a minimum punishment that must be imposed. The judge's personal assessment cannot always change that number. This tension between judicial discretion and mandatory sentencing became one of the central debates in American criminal justice, and crack cases brought that debate into sharp focus. For many defendants, the difference between a short sentence and a long sentence was not theoretical. It could determine whether their children were still young when they returned home. It could determine whether their parents were alive when they were released. It could determine whether a marriage survived. It could determine whether someone returned to the same neighborhood or found an entirely different life waiting for them. The effects could also be financial. A person serving a long prison sentence could not work normally. A family might lose income. Children might depend on grandparents. Relatives might travel long distances to visit. Legal fees could create additional financial pressure, and when the person eventually returned home, finding employment could be extremely difficult. This was especially significant because many people sentenced during the crack era were relatively young. They entered prison during the years when most adults build careers, establish families, and develop financial stability. Instead, they spent those years behind bars. When they returned, they often had little savings, limited work experience, and a criminal record. The consequences could therefore extend far beyond the original sentence. This is one reason historians describe mass incarceration as having effects across generations. A parent goes to prison. The child grows up without that parent. The child experiences economic hardship. The family structure changes, and those consequences can influence the next generation. The crack sentencing disparity became part of that larger story. But there was another important issue: the racial impact. Federal sentencing data showed that crack offenses were overwhelmingly associated with black defendants. This became one of the strongest arguments for reform. Critics argued that even if lawmakers had not intended to discriminate, the practical effect of the policy was deeply unequal. That distinction became important. The law can have unequal consequences even when the people who created it did not openly state discriminatory intentions. Researchers therefore began asking why crack markets were concentrated where they were. Why were enforcement resources focused so heavily on certain neighborhoods? Why did federal prosecutions produce such different racial outcomes? And how much of the disparity came from the drug itself compared with policing and enforcement practices? These questions were difficult. Drug markets do not exist in a vacuum. They develop within economic conditions, neighborhoods, transportation systems, social networks, and patterns of policing. Crack became strongly associated with poor urban communities. Powder cocaine was often more expensive and therefore more common in wealthier environments. That difference in price and distribution helped shape the social image of the two drugs, and the legal system responded to those images. Crack became associated with danger. Powder cocaine became associated with a different kind of user. The result was a sentencing system that reflected not only chemistry, but also the social meaning attached to each form. This became one of the most controversial aspects of the entire policy. Over time, researchers challenged the idea that crack was uniquely dangerous in every way. They examined addiction. They examined overdose risks. They examined violence. They examined prenatal effects. And they compared crack with powder cocaine. The evidence suggested that the differences were much more complicated than the original political narrative had suggested. That did not mean crack was harmless. It was not. Crack cocaine can be highly addictive and can cause serious health consequences. But the question was whether those dangers justified a punishment ratio of 100 to 1. Increasingly, experts said they did not. This scientific reassessment helped strengthen the reform movement. The debate was no longer based only on emotion. There was now decades of evidence to examine, and that evidence made the old ratio increasingly difficult to defend. But changing federal law required political courage. Some lawmakers worried about being accused of being soft on crime. Others believed that the government had already gone too far. The debate crossed party lines. People with different political philosophies sometimes reached the same conclusion for very different reasons. Some supported reform because they believed the system was racially unfair. Others supported reform because they believed judges should have more discretion. Others believed prison sentences were simply too expensive. And some believed that treatment was more effective than incarceration for certain offenders. Different arguments were pointing toward the same destination. The old system needed to change. The Fair Sentencing Act of 2010 was therefore the result of many years of pressure. It did not appear overnight. It came after decades of criticism. And when it finally passed, it represented a major change in federal policy. But the story did not end there. The people who had already been sentenced under the old rules still existed. They were still in federal prisons. Their families were still waiting. And the question of retroactivity became unavoidable. Should people who had received sentences under the old 100 to 1 system be able to seek reductions? For reform advocates, the answer seemed obvious. If the government now admitted that the old disparity was too severe, why should people continue serving sentences based on that same disparity? But the legal system had to consider another principle: finality. Courts cannot constantly reopen every case every time a law changes. There must be some stability in the legal system. So Congress and the courts had to find a balance. The result was a complicated process involving eligibility requirements, sentencing calculations, judicial review, and individual case circumstances. Not everyone automatically received a shorter sentence. Some people qualified, some did not. Some cases required additional legal arguments, and some families waited years for answers. This is one reason the history of sentencing reform can feel slow. A law may change in one day, but its effects can take years to reach individual people. Courts must interpret it. Lawyers must file motions. Prosecutors must respond. Judges must review records. And every case may have different facts. The legal system therefore moves more slowly than political headlines. That slow process became part of the lives of people waiting for relief. For someone already serving a long sentence, every month mattered, every year mattered. A delay was not simply paperwork. It was additional time away from family. This human dimension helps explain why the debate remained so emotional. The government was discussing legal principles. Families were discussing birthdays. Lawyers were discussing sentencing calculations. Defendants were counting days. Researchers were discussing statistics. Communities were discussing lost generations. Everyone was looking at the same system from a different perspective, and all of those perspectives became part of the history. The reforms that followed the Fair Sentencing Act continued to shape federal sentencing policy. But activists wanted more. They argued that 18-1 was still an arbitrary distinction. If the chemistry was essentially the same, why should the law continue to impose different penalties? The debate therefore moved toward complete elimination of the disparity. This was a much more difficult political goal. Reducing an extreme disparity was one thing, removing it entirely was another. Some lawmakers worried about the potential consequences. Others believed equality required it. The issue remained active for years. Then, in the late 2010s, another major piece of legislation entered the story. The First Step Act of 2018 became one of the most important federal criminal justice reforms in decades. Among its many provisions, the law included changes affecting certain crack cocaine sentences. It also allowed some people sentenced under the old system to seek relief under the Fair Sentencing Act. For families who had been waiting for years, this was enormously significant. It meant that the reforms were finally reaching some people who had been sentenced under the old rules. But again, not everyone was automatically released. Eligibility depended on the individual case. Judges had to review the circumstances, and the process could take time. Still, the direction of federal policy was unmistakable. The government was moving farther away from the sentencing system created during the panic of the 1980s. The 100-to-1 ratio was no longer the future. It had become history. But history has a way of leaving traces. Even after the law changes, the consequences remain. Former prisoners return home. Families rebuild. Communities remember. Researchers continue studying the effects. And politicians continue debating what should have been done differently. This is why the crack sentencing story remains relevant. It is not simply about something that happened 30 or 40 years ago. It raises questions that continue to appear in criminal justice debates today. How much punishment is enough? Should judges have more discretion? How should addiction be treated? How should the government respond to drug markets? What role should race play in evaluating the effects of a law? And perhaps the most difficult question of all, what should a society do when it realizes that one of its policies produced consequences that were more severe than expected? There is no easy answer. But the history of crack and powder cocaine sentencing shows what can happen when fear, politics, science, and criminal justice collide. A law created during an emergency can remain for decades. A number written into legislation can shape thousands of lives. And a policy that once seemed necessary can eventually be viewed as deeply flawed. The story of the 100-to-1 ratio is therefore not only a story about drugs. It is a story about how laws are made, how they affect ordinary people, how governments respond to fear, and how difficult it can be to correct the past. The next part of our story will look more closely at the reforms that followed, the people who became eligible for sentence reductions, and the continuing debate over whether America ever truly corrected the inequality created by the original system. By the time the First Step Act became law in 2018, the story of crack and powder cocaine sentencing had already lasted for more than 3 decades. What had begun as a response to the drug crisis of the 1980s had become a much larger debate about American criminal justice. The question was no longer simply how to stop crack cocaine. The question was whether the punishment created in the 1980s had been fair. For many people, the answer was increasingly clear. The old system had gone too far. But changing a law is one thing. Changing the consequences of that law is another. Thousands of people had already received sentences under the old rules. Some were still in prison. Some had already been released. And some had spent decades wondering whether the law would ever change. The First Step Act created an important opportunity for certain people sentenced under the old crack cocaine rules. For eligible individuals, federal courts could consider reducing their sentences using the Fair Sentencing Act's updated provisions. This was significant because the Fair Sentencing Act had originally changed the rules for future cases, but did not automatically give every person sentenced under the old system a new sentence. The First Step Act changed that situation for some people. It gave eligible prisoners a legal path to ask a court to reconsider their sentences. But there was an important distinction. The law did not say that everyone should automatically walk out of prison. Instead, judges were given the authority to review qualifying cases. That meant each case could involve a different set of circumstances. The judge could look at the original offense, the person's criminal history, the amount and type of drug involved, the original sentence, and the changes in the law. The process therefore became a combination of legal reform and individual judicial review. For families, however, the meaning was much simpler. There was hope. A person who had expected to remain in prison for many more years might now have a chance to receive a shorter sentence. A mother might begin imagining her son coming home. A child might finally have the possibility of reconnecting with a parent. A spouse might begin planning for a future that had once seemed impossible. But hope could also be complicated. Not every petition was successful. Some people were not eligible. Some requests were denied. Some sentences were reduced but not eliminated. And some people remained in prison. This is one of the difficult realities of criminal justice reform. A law can create an opportunity without guaranteeing a particular outcome. The courtroom remains involved. Judges must review the facts. Prosecutors can present arguments. Defense attorneys can explain why a sentence should be reduced. And the final decision can take time. For someone waiting in prison, time has a different meaning. A year outside prison can contain hundreds of ordinary experiences. A year inside can feel like an entire chapter of life passing by. People watch children grow, parents age, friends move away, relationships change, communities change, and the person inside has to experience those changes from a distance. Some people who received sentence reductions after the reforms described the experience as a second chance. But returning home after a long prison sentence is not always easy. The world outside may have changed dramatically. A person who entered prison before smartphones may return to a world where almost everything depends on a smartphone. Banking is different, job applications are different, communication is different, transportation is different, even social relationships can be different. And then there is the question of employment. A former prisoner may have difficulty explaining years away from the workforce. A criminal record can limit opportunities. Housing applications can become complicated. Professional licenses may be difficult to obtain.